and my name is Oluwapolumi Awele. I'm a lawyer, a compliance expert, and So in our previous series, we have noticed that the series or the video were too long, and I would say that maybe I got carried away with the law in talking about it. So I would be holding the phone in the in the in the event that my hand gets to pin me, then I would know that it's already getting too long. So and I think this will give room for interactive session if there is anyone on board. So today we are talking about intellectual property and how intellectual property works. By way of starting, it is important to establish exactly what intellectual property is. So, you know the meaning of property. Property is what you own, right? It's whether tangible or intangible, real or immovable. When I say real, I don't mean some properties are not real. I mean things that you can touch. They are what we call real properties. So, but for here, we are dealing with intellectual property. That is the properties that come as a result of your thinking, as a result of your thought process, as a result of your ideas and all that. So those are what we call intellectual property. They are creations of the mind. So in today's series, we'll just do an overview. We won't go like deep into it. We'll be going into, because if we say we want to go into each, we won't be able to finish in an hour or in 30 minutes. And my goal is immediately my hand starts to pain me, I will drop it. I would know that the time has gone. So, let's get right in. So, intellectual property is creation of the mind. Anything that you come up with as a product of your thinking, it's also your property. Is as much as your property, as much as a land that you bought, or as a phone or gadget that you purchase. Now, however, you have to understand that this property that you're talking about, just like land has its own value, its own economic value, your intellectual property also has its own economic value. So it's not just that you are saying that it's a property. No, you are saying that it's a property that has its own economic value. Hence, if it has economic value, it is worth protecting because it has economic value. Now, economic value is just one, among other value that it has, because it can distinguish you, which could also be tied to economic value. It can create a sort of reputation for you in the market. So all these things, if this kind of property gives you this leverage, why do you think it's not worth protecting? That's exactly what the law is saying. And that's why the law said, okay, this kind of property called intellectual property, we are going to protect it. And why should you care about intellectual property? Intellectual property gives you an economic advantage in the market. It gives you a unique differentiation. It helps you get a reward for the product of your mind. Like Wasabi would say, info laugh info, but it is only the info that you protect, that would give you money in the sense of intellectual property. You must protect it, that info that comes from your mind. That info that comes from your mind, you must protect it. So, having established the background on intellectual property now let's talk about the forms of intellectual property protection that Nigeria offers. So, basically, Nigeria offers four types of intellectual property protection. We have patents, we have trademarks, we have copyright, and we have industrial designs. Yeah, it sounds, you have been hearing this thing here and there, you know what exactly is this patent and you know in patents and designs and all that. So we'll talk about it. Let's go from patents. You probably don't hear patent as much as you hear copyright. And this is because the people that patents governs, you know, it's a set of people doing a kind of business. So a patent is basically a right that protects a product or process that is a new way of doing things, or it provides a new solution or a new technical solution to a problem. So either a new way of doing things or a new technical solution to doing things. So that's patent. Now, the way patent started was this. Patent started as a result of making colored glasses in the UK, in England. So there's a man called John of Utian. So he makes colored glasses. He brought colored glasses rather. So you know because he brought it into the UK government now under King Henry the Sixth, now decided that okay, for 20 years, only you will have access to that colored glasses. Will be that colored glasses will attach to you, to your person, and all that within the space of that 20 years. You are the only one that collects the economic benefit and all that. That was how it started in England. However, in Paris, in Venice rather, on the other hand, all those inventive devices. What do they say? The Republic say that come and inform us on it, so that we can prevent others from using them. That was how it started in Venice. So later on, we later had the Statute of Monopolies in 1623 under King James I, and patent was seen as protection of new inventions. So I just wanted you to, this history are not, they are not just for knowledge sake. Is to let you see how far back patent has gone and where we are today. In Nigeria, currently, we look at it with the eye of the law. In Nigeria, we have Patent and Designs Act. And what do we do? Or what is contained in Patent and Design Act? It's basically telling you that you see all your products, it must be the one that you want to apply for patent. It must be either new, it must be either a new product, a new way of doing things, and it must be applicable in an industrial manner. So, like I said, because of what King Henry VI gave to John of Utrecht for 20 years, that license for 20 years, that is exactly the duration of patent. 20 years. It lasts for 20 years. It means that when you register a patent, you are not going to, they will not allow anybody else to do that same thing or use that same thing without your consent for 20 years. So, take for example, if you invent like an energy saving device, or you invent like a bulb, or most recently I think I saw the video of Ken Ruye, where he said he applied for a patent of a glove that works very effectively during winter with hand gestures, So such designs or such inventions, you apply for patents. So when you apply for patents, they stop other persons, from for copying your work, at least for the space of 20 years. This is to give you a head start, as a reward for your mind, how your mind works. So now that is how it is. So the next one is trademark. Because I want to make it short, my hand is already like blinking or telling me that my hand is already telling me that, oh boy. So, trademark. Trademark is like it protects logos, signs, and all that. Logos, your logo, your tagline, your name too. However, there are some things you need to know as a startup founder or as a business owner in all this thing. First, you have to remember what I said. It must either be for patents. It must either be a new product or a new way of doing things. For trademark, before trademark, let me make notice before trademark is that there are ways for you to actually lose your patent. There are ways for you to lose your patent, in the sense that if you do not, if you have published it to the world, I think maybe we'll go deeper into this in other episodes. For now, let's just talk about the overview. So that's about patent. For about trademark, trademark basically protects your name, logo, and your symbol. Take for example, if you see Nike and you just see the sign, the correct sign, it's a logo, but it is it's now inbuilt in our mind that it is Nike. If you see a shirt that has that mark sign, it is Nike. So yeah, that's exactly what trademark helps you protect, that kind of sign. So somebody cannot wake up tomorrow and give this sign, or the mark sign, and call it Ejalonibo Enterprise. It won't work. It just won't work. Yeah. So, trademark, it protects your names, logo, and symbols that identify you. Take for example, as simple as the word, which trademark can we use now? Popular trademark that we won't get into trouble. So businesses generally have trademark. Indomie, you see their logo. Indomie, you see Apple. Let's use Apple. You see Apple, a one, as if they took a bite of that apple. You can't come again, and even if they don't put their name Apple, you know that logo means Apple, and somebody else cannot use that logo. So, but for this to be possible, you must have registered your trademark. You must have registered your trademark. Now, its trademark lasts for a period of 7 years. However, it's renewable for 40. It's renewable for 14 years. That is 14 plus 7. That's 21. Yeah, that is for trademark. That's the total amount at which you can register or register trademark. Now, what is the benefit you stand to gain from trademark? Brand recognition. Like I said, you don't need to see Nike's name on the shirt. The moment you see the mark, you already know that it is Nike that produced it. Apple, they don't need to write Apple on the phone or iPhone on the phone. The moment you see the Apple, you know that is iPhone. That's an iPhone. So that's trademark. However, because so we have noticed that some people just point at, they just target some people who have not registered their trademark and just go and register it, boom. And you think you are wise, you think say you wise, but you can't use the law as an avenue for fraud. The law won't allow itself to you. So there are ways to get by this. And if you see, there's even something that happened recently that I saw online, which is that some people registered Dirty December, and the first phrase of Dirty December was used by Mr. Easy, according to what I heard or what I saw on social media. It was first popularized by Mr. Easy in 2019. So, as somebody went to register it as a trademark in 2025, the law would not allow you to use it, it as an instrument of fraud. No, no, no. There are ways by which the trademark can be rescinded, that is, can be revoked. So, it has been established in plethora of cases, that has been established even in the law. So there are ways by which you can revoke it. So I say this to say that when you have a prior use of a trademark name, logo, and all that, you you still have a case where somebody points to your stuff and goes to register it without your consent. That is one. Also, trademark, the logo you are going to use in trademark, the name you are going to use, it doesn't necessarily have to be in operation. It doesn't have to be after you have started the old stuff. That's when you want to register a trademark. No, you can register it before you start, because the law is about proposed name, the already used name or proposed name, the already used logo or mark or proposed mark. So that is how it works. So trademark is very, very important. And because you register for CAC doesn't necessarily insulate you from the registration of trademark. As a matter of fact, trademark, CAC, if your CAC name counters any existing trademark, the law says that such a name must be changed. Such a name must be changed. So that is it for trademark. So we have seen the benefits as a founder. You have to protect these things. As a business, it gives you differentiation in the market, brand recognition. You don't have to put Apple on a phone before we know it is iPhone. Just the Apple, that just you don't need to put iPhone just for us to know it's an iPhone. No, the Apple logo on it already tells the whole stuff. The Nike logo on a shirt, I don't need to ask where you got the shirt from. Even if I don't see Nike, the moment I see that mark, it's gone. I already know that it is Nike that produced the shirt. And do you know the reason why some people still go for Ever water than some other kind of table water? It's because they trust that, oh, Ever water produces the best table water. And how do people know that this is Ever water? Number one, the logo. Number two, the shape of the bottle. Now, we would soon get to the thing, to the instrument or to the protection of the law that governs that bottle shape. Because if you look at Coca-Cola, Coca-Cola has the bottle, a particular bottle shape, and has never changed. And no brand would go and copy the Coca-Cola shape. Why? Is it because they are not smart? No, it's because Coca-Cola was smarter. Coca-Cola was smarter, but we would get to that. So the next one we need to talk about is copyright. Copyright protects literary work. Copyright protects literary work, musical work, artistic work, digital work, photography, design softwares, and all that. So Copyright is the one that you have probably heard of the most. You know, they're saying, "Oh, protect your copyright, protect your disc." Yes, these are what it governs. It governs literary work. That is, if you produce a novel, the moment you produce it, it's already attached to your name. However, registration is still important, and we have to highlight this because as business owners, there are a lot of things um, 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 to consider in business, that you tend to forget this protection side of things. So you might actually forget that, oh, I need to go and register this copyright, I need to go and do this, I need to go and do that. So people can't use that as an avenue of fraud, to defraud you. No. So if, for example, you produce a book now, I should now see it, I should now steal it from you and quickly go and register it in my name, and there is proof that I was the one that wrote it. Nah. The law will allow itself to be used as an instrument of fraud in that way. So I don't want you to see it as that the law is encouraging, only first to register. Yes, first to register owns it. That's the general rule. First to register owns it. As a matter of fact, even in patents and industrial design, statutory inventor is different from true inventor. And that's why I said we'll dedicate, an episode for patents, for copyright, to deal with them individually. So statutory inventor is different from true inventor. However, true inventor, if you run statutory inventor street, though, because if you run statutory inventor street, oh boy, it's true inventors, guys approach court, and sort that thing out. So, like I said, copyright covers literary and musical works, artistic work, cinematography work, sound recordings, and broadcast. So, this is to say that when you produce a book, when you produce music, when you produce a drawing, when you produce a form of artistic work, or digital work, it is covered by copyright. So imagine Rema dropping a song, and because he did not go and register copyright, you are not telling him that you that went to register it, you are the owner of the work. How does it sound? A sauna. So yeah, that's why I said it won't be permitted to be used as fraud. So in Nigeria, we have the Copyright Act, but it copyright governs expression of an idea, not the idea itself. Copyright governs expression of an idea, not the idea itself. It is very important to know this. Very, very important. So, the duration of copyright is 70 years after the author's death. So, it enters public domain 70 years after the author's death. William Shakespeare's work now, you will notice that people are reproducing it. Oh, somebody published by Kiniko Ade Publishers, published by Igunuko Publishers, and all that. Despite the fact that William Shakespeare wrote it, you ask, why is this estate not suing? Why is this? No. IP is not to deprive the world from inventions. No, it is just to give added advantage, or is to reward the author. It's not to deprive the author. So don't while it is exclusive, in a sense of way, there comes a time when IPs revert to the public domain, and that is when the public enjoys. So take for example William Shakespeare's work now. People reproduce it 70 years after the author's death. That's the duration of IP. So for industrial design now, we spoke about Coke bottle. So anything that is three-dimensional shape, or shapes, patterns, or colors that have visual appeal. These are what we call industrial design. So if you're a founder and you are making something hardware, something hardware, something that has to do with physicality, consider industrial design protection. So it's also governed by the Patent and Designs Act. Remember the patent we spoke about before? That's why I said it is very, very, close, but they are not the same. For industrial designs, you must have industrial applicability. So this only lasts for 5 years and is renewable twice. That is 5 plus 2 times of 5, that's 15. The initial registration is 5 years, renewable for another 5 years, which can be renewed twice. That's 10 years, then plus the initial 5, that's 15. So take for example, if you that Coke bottle shape now, it's an industrial design, which it's a design. So why should you consider IP? Let's round up. Why should you consider IP? You should consider IP because of ownership, because of investor confidence, and competitive advantage. The legal protection it gives you, you should actually consider it, because as much as we don't seek to deprive the public of invention, we also seek to restrict the public for the time being. For the time being, pending the time you have your own added advantage, then after which it can revert to public domain. So yeah, your IP is your silent co-founder, and I want you to treat it as such. If there is any question, and yeah, just practical tips. Try to register before you begin your work. Try to register your trademark before you begin to run your business. Try to do an independent IP audit, to know exactly what are your advantages, what are the things you have that are your intellectual property assets, and yeah, from there you can know what to register, because if you don't know, there's nothing you can do. So do an independent IP audit, know exactly where you stand, then register it accordingly. Register what matters, and you can use an NDA or contract, to protect some ideas. But like I said, IP majorly protects expression of ideas and not the ideas themselves. Monitor and enforce it. There's no point in registering and not enforcing what you register. If somebody breaches it, take that person to court. Take that person to court. And yeah, consult experts. We are always available to talk to you about IP and how it goes. Remember, these are just the general rule. There are exceptions and exceptions and exceptions and exceptions and exceptions. In fact, there are exceptions to the exception to the exception to the exception. So consult experts. They'll tell you more about it. But for now, this is just a general overview of what IP is. So yeah, I think that is it. And I think this is the end of today's session. Thank you very much for joining. And yeah, bye.